Welcome, and thank you for joining us for BakerHostetler's Class Action Defense 2024 Mid-Year Review webinar. I am Julie Singer-Brady, co-leader of BakerHostetler's Class Action Defense team. Joining me today is my co-leader of the Class Action Defense team, Bethany Lukic, as well as BakerHostetler's Privacy and Digital Class Action and Litigation team leader, Paul Carlscott, BakerHostetler's Financial Services Industry co-leader, Carl Franter, and Kevin Zimmerman from our Insurance Class Action team. Today, we'll be discussing significant cases and developments in the class action space over the course of 2024 and offer our predictions as we head into 2025. This is a 1 hour and 15-minute presentation. We'll do our best to answer any questions during the presentation, which you may enter in the chat function. For questions we do not get to during the program, please feel free to reach out to us. The program will focus on the following areas: privacy and data risk class actions, presented by Paul; insurance class actions, presented by Kevin; financial services class actions, presented by Carl; Bethany and I will address false advertising and labeling class actions, and then Bethany will close out the program with mass arbitration. Some house notes. This program is approved for CLE in California, Colorado, Florida, Georgia, Illinois, Missouri, North Carolina, New York, Nevada, Ohio, Pennsylvania, Texas, and Virginia. New Jersey is available via reciprocity. Iowa, Indiana, Kentucky, Tennessee, and Washington are pending. During the program, we will share two CLE codes, which you will need to write down and enter in the post-webinar survey in order to receive the CLE credit. You should see the first CLE code now. The post-webinar survey will begin immediately following this presentation, so there is nothing you need to do to start it. If for any reason you have any trouble, please email Cassie Blaine, CBLAINE, at bakerlaw.com for a PDF of the survey. This email information will be provided at the end of the program as well. And now I'll hand it off to Paul, who will talk about privacy and data risk class actions. Paul?
Thanks, Julie. Hello, everybody. I will be talking about some developments in privacy class actions that have occurred over the last couple of months. If you attended our most recent webinar, you will have seen my colleague, Casey Collignon, provide updates on many of these same topics. So what I've tried to do is add what's happened since then. We'll be covering a little bit about what Casey covered the last time, and then some interesting thoughts looking forward. We'll be tackling the following issues. Because of the length of time I have, I'm going to be taking a pretty high-level approach to these. There's more detail in the slides, and I'm not going to be covering everything that's in the slides, but the slides should be made available for you for review afterward. First topic will be trends in data breach class actions with specific reference to standing issues as well as class certification developments. Next, developments in healthcare web tracking, which is a particular area of a lot of activity over the last couple of years. And then the next one will be California privacy class actions, another big trend. I'll cover very briefly updates in BIPA and VPPA class actions, and then we'll end my part of the presentation with a discussion, looking forward discussion on the possible impacts of AI in privacy litigation. So that will be what we'll cover, and let's start with data breach class actions. So again, if you were here the last time for Casey's presentation, you will have noted that she covered a lot of these same cases. There have been a few recent developments on the class certification front. Class certification is an area in data breach class actions that I'm often asked about, and the answer when asked about how many cases have been certified is very, very few have ever even reached this stage. But that number is growing, and it has grown by quite a bit over the last year and a half or so. We had the 3 decisions in 2023, CareFirst, Marriott, and Brinker, that Casey would have talked about during the last discussion. And then the Blackbaud case, which was that decision was issued in May of this year. And they add on to maybe another handful of cases that have been decided in the past. Generally speaking, defendants have done well on class certification and data breach cases, but there are some nuances. And so I'll cover just the ones that are listed here briefly. The Care First case, I think the last time we presented on this was an example of a good case denying certification. Since then, though, in March of this year, the district court did certify a case for nominal damages. Now, the question that is always in my head about nominal damages is, what does nominal damages mean in a class action? Does it mean $1 for millions of people, or does it mean $1 each for millions of people? That's a big question that I think the courts are going to have to grapple with. But certainly the idea of nominal damages being assessed across the class does eliminate one of the key issues in class certification, particularly in data breach cases, which is that both the causation of injury and the amount of damages is very individualized in most cases. And so that court addressed that issue and found that nominal damages was something that could be dealt with on a class-wide basis. So we'll see where that one goes. In Marriott, the most recent development is that the Fourth Circuit just accepted a second interlocutory appeal after the district court, a new judge, recertified the class on remand in that case. So more to come in Marriott. The Brinker case is one that we see plaintiffs raise all the time in mediation, saying that the tide has turned and now everybody on the plaintiff side thinks that all data breach class actions are certifiable. The thing to note about the Brinker case is that it involved credit card data, and credit cards are a very specific type of data breach, and you don't see them as much anymore. So for one thing, it's a little bit of an anachronism. But the second thing is credit card data breaches are clearly intended to steal credit cards. Most current data breaches that we see are not necessarily intended to exploit financial information, other than in many cases to try to get the victim, the company that's the victim of the data breach, to pay a ransom. And oftentimes the way the attackers do that is by threatening to publish personal data, but that doesn't necessarily mean that the personal data itself is ultimately going to be used for any actual bad act or identity theft. And so Brinker, you need to take it with a grain of salt, and there are actually some pretty good individual statements in that opinion that I think in the district court's opinion, which was in part reversed by the 11th Circuit, that are actually very defendant friendly. And then finally, the Blackbaud decision is the most recent one. In that case, the court denied class certification essentially based on the ascertainability element, that the class members were not ascertainable. Blackbaud's a little bit unique in the sense that the breach happened with a vendor, and the customer data that was affected, or the individual personal data that was affected, was personal data for customers of Blackbaud, so corporate customers of Blackbaud. So there are a couple of levels that had to be considered in terms of whether the class could be identified. But the other thing the Blackbaud decision really illustrates is the disconnect between the methodology that might be used at the incident response level to identify people that need to be notified of a breach, because that standard is very broad and includes, the information was potentially compromised, for example, and comparing that to what might need to be proven in a class action in order to recover damages based on various causes of action. And so the court in that case found that that disconnect was too great, and you simply couldn't rely on the notification list to ascertain who's in the class action class. So very important decision for that reason. Again, take it with a little bit of a grain of salt because it's a little bit unique. Next slide. One interesting trend, and this is anecdotal, so don't put too much weight into this, but I thought it was worth commenting on. Some of our team at Baker recently had a settlement that they presented in Florida to Judge Mizell in the Middle District. That was an agreed upon settlement, and she, sua sponte, didn't approve the settlement and dismissed the case on standing grounds. because she concluded that there wasn't sufficient standing even for her to adjudicate the class action or the class settlement. What she did then was she issued show cause orders in the rest of her data breach cases. And this also illustrates how many data breach cases are out there, asking the parties to show cause why those cases shouldn't be dismissed. So I think this is an illustration of the issue of standing over the years has gone through various ups and downs. And I think we're sort of in a place now where maybe we're starting to see a resurgence of standing having some teeth. So we'll see what happens next, but that's I thought an interesting thing to note. Next one. One big area of litigation, as I said before, has been web tracking litigation against hospitals. I won't spend a lot of time. There's a lot of information on the slide here that I'll commend to your reading. But a couple of the highlights here are we're starting to see more settlements. The settlement value in these cases still has hovered around $4 to $6 per person, but that kind of depends on how you define the settlement class. So, for example, the Mass General Brigham case that's listed there, 18.4 million, that was at about $6 because there were 3 million people, because the settlement class included all patients, regardless of whether they actually used the website. The next one, Freighted Health, was about $4 a head, and that was because that settlement class only included patient portal users of about 500,000 people. And so you can see that the range remains somewhat constant. We're seeing higher ranges for very small classes, and there are some exceptions to this in terms of cases that either have gone really badly or really well for defendants or plaintiffs, are settling outside this range. But we are seeing that kind of settle kind of into that range, at least right now. And then the other kind of key issues that we're seeing right now, a lot of split the baby decisions on motions to dismiss. Oftentimes we see a dismissal the first time around with leave to amend, and the second or third bite at the apple, the plaintiffs are able to get a claim that sticks. One of the key decisions that has been issued recently is in the MedStar case. We were able to get an order granting summary judgment after that court had denied class certification. So that case is the first to be fully adjudicated, and it was adjudicated favorably to defendants. So some good developments, but overall, this is an area of a lot of activity and a lot of uncertainty. Next slide. I won't deal with this in detail. Bethany's going to cover some of the related trends in what we were calling SIPA, or California-specific pixel litigation. But generally speaking, we're still seeing lots and lots and lots of these cases filed. Most of them are what I call drive-by cases, where the plaintiffs that are bringing them are looking for a quick settlement. But sometimes the defendants don't want to do that. And so there have been a few cases to reach decisions, and some of the more recent ones are listed here on the slide. So again, commend those to your reading, and happy to answer questions about the trends here, but we're still seeing high volumes of these cases. Most of them are not serious in terms of the plaintiffs looking for large class settlements, but there are some exceptions to that. Next slide. BIPA, not a lot of activity in BIPA recently. I just wanted to highlight kudos to Bonnie Delgado, who got a big win earlier this year on the healthcare related aspect of this. So that's really the most recent key development in BIPA litigation. BIPA, for those of you that aren't familiar with it, is the Biometric Information Privacy Act. It's specific to Illinois. There are some other states that have similar laws, but most don't have private rights of action. So most of this litigation is focused on Illinois specific. Next slide. VPPA. Most of this is the same as we presented the last time. So again, I'll commend this to your reading of the slide itself. But the main new trend is at the very bottom of the slide, that there are a few firms that are now focusing, instead of video sharing with ad tech companies like Facebook, that was the previous trend. Now, some of the cases are focusing on sharing with internal vendors, marketing vendors and that kind of thing. So new trend to watch out for, but VPPA still has been slowing down a little bit. but it's another one of those things that sort of comes and goes. So it's been hard to kill it dead. And then again, for those of you that aren't familiar with the acronyms, VPPA stands for the Federal Video Privacy Protection Act. Next slide. I'm going to end with AI very, very briefly. This is really more food for thought. The one thing about AI is that we're not seeing a lot of class actions that I would consider are focused on privacy violations based on AI quite yet. One of the, I think, challenges here is that AI is such a broad term. And again, this is a slide for those of you that attended last time, probably saw this. Casey presented this. But it just sort of illustrates the various things that can be part of AI, and there's a lot of them. What I tried to do, and moving to the next slide, is come up with just some brainstorming about places that at least this is just Paul speaking, I see privacy-related risks associated with AI. So for example, relying on AI for information security, that's a data breach-related risk. So we're seeing AI used in a lot more contexts, and it creates the potential for additional vulnerabilities. AI can also be an aid to criminal activity, so it may also impact data breach litigation in that way. What I don't see quite yet is the HAL 9000 scenario where the computers start to act on their own behalf and rebel from us. I think we're a far way out from there, but that's one of the things that makes AI sexy. Is that's the first thing that pops into a lot of people's head when they think about AI. For privacy-related risks, there's quite a few of them, and you have to think about AI in different ways. But one of the key ways that I see AI becoming an issue early on is in failing to accurately disclose what kinds of AI are being used and how AI is being used in terms of how customer data is being evaluated, used, transmitted, shared, sold, and that kind of thing. And so historically, we think about those types of activities as being algorithm-based, and AI is really just the next form of an algorithm. And so we're already seeing litigation about that kind of thing, and AI, I think, is just going to make for more arguments on the plaintiff's side. Related is using AI on data that may have been collected for some other purpose. So a lot of companies have amassed data over the years. And the question is, are you entitled to use AI to evaluate that data in ways that may not have been intended when you collected it in the first place? The next one is just not understanding what AI generated code might do. So a lot of companies are using code that's been generated by AI. That takes the human element one step removed from it. And so what we see in a lot of our privacy cases now is that our clients don't really even understand what their technology does, and AI has the potential to exacerbate that. And then new data that's created by AI to begin with is another one. And then the big one that I see as being an argument that we're going to have to face in privacy litigation is this argument that we're already seeing that the big tech is so sophisticated that no data is truly anonymous. The argument that somebody like Google or Facebook can figure out who you are based on any data that they might be able to gather. And that is true to some extent. The big question is whether they actually try to do it or have any incentive to do it. And so that's really a different question. So some other risks listed there, but in the interest of time, I'll commend them to your reading. Happy to answer any questions. But with that, I'll turn it over to Kevin to talk about insurance.
Good afternoon, everyone. My name is Kevin Zimmerman. I'm an attorney in our Columbus office and a member of our insurance class action team. We'll be covering a few different topics arising from the insurance class action space, which have applications for class action practice more generally, and hopefully are insightful for all of your industries and practices. Slide, please. We'll start with total loss class actions, which are still percolating around the country. The background here is that when an insured makes a claim for automobile insurance and the car is deemed totaled, the insurer's obligation is to typically pay the actual cash value of the vehicle before it was in the wreck. Most insurers use specialized third-party valuation services, separate companies, to estimate the pre-accident value of the totaled vehicle. And these class actions challenge various adjustments or other aspects of those estimates. Just last month, the Ninth Circuit released an important class certification opinion in one of these cases, that provides a good case study and some good lessons to learn on the issue of predominance more generally, and we'll take a look at that. Next slide. So to set the stage, we'll go back a few years to the Ninth Circuit's opinion in Lara v. First National, which was another total loss valuation class action. Here, plaintiffs challenged the condition adjustment used to value total loss vehicles. The valuation company here used advertised prices from dealerships as so-called comparable vehicles to determine the pre-accident value of the total vehicle. But dealer vehicles are refurbished and reconditioned before they're resold, and therefore they're more valuable than the typical vehicle on the road, and they would overestimate the value of most vehicles on the road. So the condition adjustment at issue here accounted for that difference, and then also accounted for the unique condition of the vehicle itself with an additional positive or negative adjustment. Plaintiff challenged the legality of the condition adjustment, but the Ninth Circuit held that class certification was not appropriate. The court explained individual inquiries would be required to determine which class members were actually underpaid, because for each and every insured, you have to look at the pre-accident value of the vehicle and then compare that to whether what the insurer actually offered to determine whether it was more or less. The court recognized the value of any given vehicle on the road is a highly individualized inquiry, so plaintiff couldn't satisfy predominance here. Importantly, the court also recognized that this is a liability issue, not just a damages issue. Since the fact or the existence of damages was an element of the underlying cause of action for breach of contract, a fact finder could not determine liability for any class member without conducting these individualized inquiries. Next slide. So that brings us to the new case from last month, Jama v. State Farm. In this case, plaintiff challenged a similar condition adjustment, but also challenged a so-called negotiation adjustment that the insurer and the valuation company used. The theory behind the negotiation adjustment is that consumers typically negotiate down from the listed price of a vehicle for sale by a dealer. When you go into the dealership, you don't always pay sticker price. You have an opportunity to sort of negotiate down the price of the vehicle. So again, if you just use dealer list prices, you could overestimate the value of any given vehicle. The separate negotiation adjustment at issue here attempted to account for that. Next slide. Jama recognized that the court's prior holding in Laura precluded class certification of a condition adjustment class, but it also reasoned that the negotiation adjustment was different and allowed certification of that class. Why? Everyone agreed that some condition adjustment was lawful, so the question there was whether any particular condition adjustment was correct or not. But for the negotiation adjustment, plaintiff's argument was that the adjustment was unlawful vel non. In other words, plaintiff argued that unlike the condition adjustment, no negotiation adjustment was ever lawful under the Washington regulations. And whether or not plaintiff was right or wrong about that, the court believed that that was an issue that could be determined on a class-wide basis. Unlike the condition adjustment, there was no need to conduct an individualized inquiry to determine whether the amount of the adjustment was correct in any given case. At least under plaintiff's theory, any negotiation adjustment was unlawful, and the legality of the adjustment was therefore, in the court's eyes, a common question supporting class certification. Next slide. Jama is a good case study for predominance because it offers lessons on how to frame predominance issues in your cases more generally. If the challenge conduct can be framed as either always unlawful or not, like the negotiation adjustment, predominance is easier to satisfy. So for defendants, it's important to develop examples where the alleged conduct is not wrongful, perhaps because it doesn't lead to an injury or an underpayment for certain members of the putative class, as with the condition adjustment. If you can develop those kind of examples, the wrongdoing starts to look more like the condition adjustment in JAMA, where individualized inquiries are required to determine whether or not the allegedly wrongful conduct actually resulted in injury or underpayment in any particular case. And when these kind of individualized inquiries are necessary to determine which class members were or were not harmed, it's much more difficult to satisfy predominance. Looking forward, total loss class actions have been working their way through the courts for a while now, and the opinion in JAMA is really emblematic of how these cases have split across the country. Those cases challenging condition adjustments or challenging valuation procedures more generally have failed class certifications for the reasons discussed in Laura. You need an individualized inquiry as to each and every vehicle. But multiple cases in which plaintiffs have pointed to particular adjustments which might be entirely unlawful, have resulted in class certification, essentially for the reasons discussed in JAMA. Slide. Because those lines are starting to be pretty clearly drawn at this point, we're starting to see plaintiffs come up with more and more novel theories to try to find the next big ticket in the total loss class action space. I list some examples here that our team has handled. The equity surplus theory arose in California and alleged that insurers were required to pay total loss claims for leased vehicles directly to the insureds rather than the vehicle lessors themselves. We achieved Rule 12 dismissal of one of these claims based on the understanding of the contract and sort of the background principle that it's the lessor that actually owns the vehicle and the lessee is just paying for the sort of right to use that vehicle. A subsequent case against another insurer was also dismissed thereafter. The salvage title valuation theory comes from Pennsylvania, and there plaintiff alleged that vehicles with so-called reconstructed title shouldn't be valued less than vehicles with clean title. The argument in that case is that reconstructed title is essentially a certification from the state government that the vehicle is okay to drive again after a prior total loss, and therefore shouldn't be adjudged less than vehicles with clean titles. We secured dismissal here too, and we haven't yet seen this theory pop up anywhere else since. The conversion theory I note here was another case in California, alleging that insurers improperly converted total loss vehicles by requiring insureds to transfer title of those vehicles as part of the total loss claim. Here we move to dismiss, arguing that the California regulations essentially expressly not only allow but require that process, and the plaintiff subsequently moved to or voluntarily dismissed before filing response. Without a published opinion rejecting the theory, though, we've been on the lookout for any other copycat cases who might be raising this similar theory. Finally, the EV tax refund theory is a recent case we saw. It stems from allegations that an insurer improperly used post-tax refund prices listed by a dealer. So the dealership, when advertising the vehicle, listed the price of the vehicle after an applicable tax reduction, and the plaintiff alleged not all consumers might qualify for that refund, so that's improperly decreasing the price of comparable vehicles. Next theory, the next slide. Our next topic here is standing in insurance class actions. Anyone who's come to these presentations before has heard me talk about how standing can be both a merits defense against the named plaintiff, but also a class certification defense. More and more cases are recognizing that if individualized evidence is required to prove which class members do or do not have standing, that can cut against predominance. Next slide. One case to keep an eye on for the predominance point is a recent Rule 23F appeal in the Sixth Circuit, Clippinger v. State Farm. This was another typical negotiation adjustment case, similar adjustment to that which was certified in JAMA. Here, however, the insurer argued that the named plaintiff and the other insureds did not have standing because their claim was paid pursuant to a separate valuation procedure. Rather than using the valuation with the allegedly unlawful adjustment, the parties here agreed to conduct an appraisal of the vehicle, and plaintiff was paid pursuant to that separate appraisal procedure. According to the district court, this did not implicate Article 3 standing. Plaintiff had still alleged that there was a legal injury, a breach of contract, and according to the district court, this alleged legal injury was sufficient to confer standing for the named plaintiff and all other class members. In other words, whether or not any class member was underpaid, the district court said that the breach was sufficient to confer standing for everyone. Next slide. The district court certified a class here, and the Sixth Circuit recently accepted a Rule 23F petition. One of the central issues on appeal is the intersection of TransUnion and class certification. Next slide, please, Betsy. As recognized in Watson v. Progressive, though, which is a district court case that stayed its proceedings pending resolution of Clippinger, the Sixth Circuit may have to reassess its prior holding that a legal injury can confer standing for an entire class. And if a legal injury isn't sufficient to satisfy standing, the Sixth Circuit may have to wade into the issue of whether individualized standing inquiries defeat predominance. Again, if the court has to conduct a mini trial to determine which class members do or do not have standing, that can defeat predominance. So Clippinger is definitely a case to keep an eye on to see the continuing intersection TransUnion standing with Rule 23's predominance requirement. Next slide, please. Apart from the certification implications, recent insurance class actions have also reinforced the power of standing as a merits defense against the named plaintiff himself or herself. These cases are important on their own terms because the more bite in Article 3 has on the merits, the more power it has as a class certification argument too. That's because the easier it is to challenge standing for any given individual, the more often that defendants will be able to find examples of putative class members who may or may not have standing in the class, which gives rise to the predominance issues I mentioned. Next slide. One recent case of standing as a merits defense comes from the Third Circuit. This was another total loss valuation case where the plaintiff challenged a condition adjustment for total loss vehicles. But in this particular case, the insurer actually applied a separate upward adjustment to settle, which effectively was a compromise payment to resolve the claim. Court looked at that payment and said, well, plaintiff, you were paid more under that positive adjustment than the alleged negative impact of the condition adjustment, so you didn't suffer any real-world financial injury. The plaintiff attempted to argue that the insurer might have paid even more if the negative adjustment wasn't applied, but the court said that was too speculative. There was no real-world financial injury, and thus the named plaintiff lacked standing. Next slide. The next standing merits case comes from the Fourth Circuit, another insurance class action. Here, the Centers for Medicaid and Medicaid Services, CMS, had sent a collection letter to the plaintiff asking her to reimburse CMS for certain treatment her deceased husband had received. The plaintiff alleged that it was her insurer's obligation to reimburse CMS and brought putative class claims on this issue. According to the court, though, the collection letter wasn't sufficient to confer standing for the named plaintiff. Plaintiff hadn't yet paid anything to CMS, so there's no existing monetary harm. The court explained that the risk of future monetary loss can establish injury in fact for injunctive relief, but it couldn't, by itself, establish a concrete injury necessary to seek damages. So looking forward, as Paul mentioned, I think we're going to see more and more courts address Article 3 standing as a merits defense. And the thing to look out for in cases like the Sixth Circuit Clippinger case are more and more courts recognizing that the individualized standing inquiries can lead to severe predominance problems as well if the court has to conduct a mini trial as to which class members do or do not have standing. With that, I'll pass it on to Carl Fanter to give an update on financial services class actions.
Thanks, Kevin. I help lead Baker's financial services industry team, and I'm excited to be presenting today. Next slide. First, I'm going to discuss key Supreme Court decisions from the recent term that impact not just class actions, but the entire financial services industry. Second, I'm going to review some recent class action decisions, including ways that courts are analyzing standing, similar to the way that Paul and Kevin discuss some issues in their spaces. Third, I'm going to touch upon how the CFPB's recent pronouncements may impact future class actions, as well as the financial services industry generally. Next slide. In Loper-Bright, the Supreme Court overruled the doctrine of Chevron deference, which counseled courts to defer to agencies' interpretations of ambiguous language in the statutes they administer. The decision impacts nearly every area of federal law, essentially nearly every statute that's administered by a regulatory agency. Until now, an agency got a thumb on the scale, so to speak, with respect to questions of statutory meaning and authority. Now it does not, at least not as a formal matter. Legal questions that had been regarded as settled because the agency decided how to interpret a given provision may now be up for grabs. Next slide. Now, many of the statutes providing for the authority of regulators governing the financial services industry expressly give a fair amount of discretion to those agencies. So, at least compared to other industries, it may be more difficult to challenge a federal banking agency's interpretation of a particular banking statute, including causes of action that often give rise to class actions, like the Truth in Lending Act or the Electronic Funds Transfer Act. Next slide. Another recent key Supreme Court decision is the Consumer Financial Protection Bureau versus Community Financial Services. So there, a trade association representing payday lenders challenged the CFPB's rules. The Fifth Circuit panel held that the CFPB's funding structure is unconstitutional because it violated the Appropriations Clause. The Fifth Circuit did a detailed analysis, and it was concerned about the CFPB receiving funding from the Fed, which is itself outside of Congress's appropriation process. The panel characterized the CFPB's funding as a double insulation from Congress's purse strings. The Supreme Court, however, reversed and upheld the CFPB's funding structure, holding that it satisfied the appropriations clause. Next slide. As the court acknowledged in oral argument, the case called into question not only the CFPB's funding, but arguably the constitutionality of other federal banking agencies like the OCC and the FDIC, as some of those agencies are also insulated from the traditional congressional appropriation process. Given the ruling, there may be an increase in enforcement actions, which often leads to parallel consumer class actions. In fact, after the Supreme Court's decision, the CFPB Director Chopra announced that the CFPB would be, quote, firing on all cylinders. Next slide. Quintero is a class action challenging Bank of America's failure to comply with the New York law requiring lenders to pay at least 2% interest on funds held in a borrower's mortgage escrow account. Effectively foreclosing the lawsuit, the Second Circuit held that the New York law is preempted for the defendant National Bank because the law purports to exert control over the bank's powers, namely the power to provide escrow accounts on behalf of its customers. According to the Second Circuit, the degree of the control is irrelevant because the preemption test doesn't turn on how much a particular state law impacts the national bank. But in a 9-0 decision, the Supreme Court reversed and reaffirmed that a state consumer financial law may still apply to a national bank, so long as that state law doesn't prevent or at least significantly interfere with the national bank's exercise of its powers. Next slide. The court's ruling sets out federal preemption principles that apply across a broad range of financial consumer products that are the subjects of class actions, not just mortgage escrow accounts. But as a result of the decision, and remember, there's no bright line rule that's been established, future district courts and appellate courts are going to have to perform a pretty detailed comparative analysis when evaluating the potential preemption of a state consumer financial law in a class action. And as a practical matter, the court's decision may actually lead to increased litigation about these issues, given the lack of a bright line rule. Future courts are going to have to decide whether those consumer financial protection laws interfere with the powers of national banks, especially because Loper, the case I discussed a few minutes ago, may mean that the agency's preemption guidelines for banks and financial institutions no longer receive deference by courts. Next slide. Now I'd like to turn to how courts are analyzing standing and class actions in light of TransUnion, issues that Kevin and Paul discussed earlier. The basic holding of TransUnion is no concrete harm, then no standing. So in other words, even when Congress has provided a federal cause of action, the mere fact that that law has been violated will not, standing alone, provide a right to sue in a federal court. So for the last few years, courts have been grappling with two key issues stemming from the TransUnion decision. And that's basically has widened the door for standing-based challenges to class actions, both at the Rule 23 stage as well as the Rule 12 and Rule 56 stage. First, each claim and form of relief requires separate standing to sue, and each class member must have standing. And second, proving injury in fact or a concrete injury for statutory claims that are often brought as class actions requires comparing the alleged harms covered by the statute to existing common law claims. Next slide. So in Roldan, plaintiffs filed a class action alleging the defendant's online banking services agreement, challenging it. The agreement included a non-disparagement clause under which the bank could suspend or terminate users' access if they made any statements that exposed the bank to liability or brand damage. The plaintiffs argued that the clause violates a section of the California Civil Code, barring provisions that waive a consumer's right to make statements regarding the seller or concerning the underlying goods or services that have been purchased. Now, recently, the district court dismissed the complaint, but not expressly based upon standing. So it'll be interesting to see how the Ninth Circuit analyzes these issues. Next one. In Merck, a job applicant brought a Fair Credit Reporting Act class action against a prospective employer defendant. Essentially, the plaintiff alleged that the violations of FCRA by the employer led him to not being hired. So relying on TransUnion, the Sixth Circuit affirmed the summary judgment for the defendant because the alleged informational injury from the purported FCRA violation was insufficient to give standing to the plaintiff. The Sixth Circuit observed that recent case law has thrown cold water on the notion that Congress could expand constitutional boundaries that the Supreme Court has set out to govern standing. In other words, the Sixth Circuit is saying that Congress, by passing statutes that allow for causes of action that often become class actions, Congress can't lower the floor that the Constitution has set with respect to the standing requirement. Next slide. Just last week, the Fourth Circuit issued a decision in Fernandez, helped by defense attorneys for BakerHostetler, which was another purported class action for a FCRA violation based upon the defendant's issuance of erroneous possible OFAC matches, sort of a terrorist watch list, in a screening report for the plaintiff. The court stated that the misleading information had to have been brought to the attention of a third party who understood its defamatory significance. But in this case, the evidence was that the defendant's employee reading the erroneous report had no idea what the report meant, and importantly, took no adverse action upon the plaintiff. So the court reasoned because no third party read or understood the inaccurate OFAC information giving rise to the FCRA cause of action, there was no concrete injury sufficient to support standing. So stepping back as a whole, including the cases that both Paul and Kevin talked about, what do these cases about standing mean? From my perspective, I just think over the last few years, challenging Article 3 standing has been a much stronger tool for class action defendants than it used to be. Next slide. Next, I'd like to briefly discuss recent communications from the CFPB. Just last month in August, the CFPB reiterated that existing laws, including consumer protection laws, apply to financial institutions' use of AI, no exceptions at all. And by flagging certain areas like fraud detection models, chatbots, and loan originations, those areas may be more likely to give rise to consumer class actions in the future. Next slide. Regulators have also recently emphasized their focus on fintech partnerships and relatedly, additional emphasis on deposit account practices, including consumer protection issues regarding those practices. Regulators appear to be concerned that the financial institutions are partnering with these companies, which lack the same oversight as the institutions and may not have the same goals as the financial institutions subject to regulation. Next slide. Finally, just two additional recent Supreme Court cases from the last term that bear on financial institutions and potential class actions. In Jarksy, the court held that when civil monetary penalties are pursued in a fraud case, a defendant has the right to a jury trial, and an administrative law judge is not sufficient. And this matters for banking regulators who also use ALJs. And in McQuarrie, the Supreme Court unanimously held that pure omissions are not actionable under Rule 10b-5. An omission would only be actionable if it renders affirmative statements misleading that had actually been made. Well, thank you all for your time. And now I'm going to pass it along to Bethany and Julie to discuss recent developments in false advertising and labeling class actions.
Thanks, Carl. Before we delve into developments in false advertising and labeling class actions, I'm going to piggyback off of Carl's section on financial services class actions with a brief PSA, if you will, to any attendees from companies who send emails to Florida residents that in any way address billing. There have been in the last two plus years, well over 1,000, if not thousands of cases, most of them styled as putative class actions, filed in Florida State Court, and we've defended a number of them, against companies who send emails to customers or clients that pertain to payment. The Florida Consumer Collection Practices Act prohibits activities in collecting consumer debts. And notably, unlike its federal counterpart, this applies to any person collecting a debt and is not limited to debt collectors. So companies collecting their own debts are subject to the FCCPA. But the prohibition at issue is that in collecting consumer debts, no person shall communicate with the debtor between the hours of 9 p.m. and 8 a.m. in the debtor's time zone without the prior consent of the debtor. While this subpart references telephone calls specifically, there are now at least 4 firms in Florida filing cases against companies that send emails about not just attempting to collect debt, i.e. a past due payment, but upcoming payments. Notice that an invoice is now ready to be viewed, simple notifications of auto pay or auto debits, and virtually any type of email at all that mentions in some form payment. To date, there have been no decisive rulings as to the applicability of this provision of the FCCPA to emails, but companies are being forced to defend or settle. So unless there is a definitive precedential ruling that this provision of the FCCPA specifically does not apply to emails, you may want to consider ensuring that emails are not sent during this time frame, or obtaining consent to send emails during these hours, which can be done in conjunction with customers signing up for email notifications or electronic payments. Now on to false advertising and labeling class actions. I am going to discuss recent key decisions impacting the reasonable consumer standard, pleading and proof requirements and deceptive labeling claims, and then preemption. Next slide. The reasonable consumer standard, a refresher. I believe courts in most circuits define the reasonable consumer standard the same way. Deceptive acts are defined objectively as those that are likely to mislead a reasonable consumer acting reasonably under the circumstances. As it pertains to deceptive labeling claims, the Ninth Circuit has articulated that the reasonable consumer standard requires a probability that a significant portion of the general consuming public or targeted customers acting reasonably in the circumstances could be misled. Note, this is a probability, not the mere possibility that defendants' labeling could conceivably be misunderstood by some consumers. Courts in other circuits have quoted this proclamation by the Ninth Circuit. And in June 2023, the Ninth Circuit addressed what a court can consider in determining whether a label is deceptive, holding in McGinnity versus Procter & Gamble that the front label must be unambiguously deceptive for the court to disregard the back or side label. Next slide. I want to touch on the McGinnity decision because it's been the subject of much debate and analysis in the 15 months since it was rendered. In that case, a consumer alleged that bottles of shampoo and conditioner that contained the phrase natural fusion and had an avocado on a green leaf with a gold vitamin misled him to believe that the product was all natural, or at least more natural than it actually was. The Northern District of California granted the defendant's motion to dismiss, finding that this phrase did not reasonably mean the absence of synthetic ingredients, which could easily be confirmed by reference to the ingredients on the back of the bottle. On appeal to the Ninth Circuit was the question of whether the court could consider the back label. The Ninth Circuit affirmed, finding the lower court could because the front label was ambiguous. It wasn't misleading or, as the court put it, unambiguously deceptive. And therefore, any ambiguity could be resolved by reference to the back label. There has been a lot of discussion and analysis as to whether this was a change in the law or whether this merely clarified and synthesized exacting jurisprudence in the Ninth Circuit. In one decision, the Central District of California has recognized McGinnity as creating a bright line rule and actually reconsidered and then reversed a prior order denying a motion for summary judgment on this basis. Next slide. While McGinnity has been hotly discussed over the last year plus, it was actually in accord with a decision from the Second Circuit, which had been rendered about 3 weeks prior to McGinnity, where the Second Circuit addressed whether the court can consider the back of the package of tortillas in addressing the plaintiff's claim that graphics that were red, green, and white and resembled the Mexican flag and had the phrase "a taste of Mexico" misled him into believing the tortillas were made in Mexico, even though the back of the label clearly said "made in the USA." The Second Circuit there expressly rejected plaintiff's argument that there was a precedent. The precedent established that there was a rule that information on the back of the product's packaging is always irrelevant to a deceptive marketing claim. Now, in the 15 months since McGinnity was rendered, there have been at least 60 decisions available on Facebook, on Westlaw that cite to McGinnity. Most of these decisions to date are decisions from district courts in the Ninth Circuit. However, there are a handful of cases within other circuits, specifically district courts in Maryland, New York, Illinois, and Texas, that have cited to McGinnity in holding that the entire packaging can be considered. Notably, 2 of these cases are currently on appeal, the 2 cases I have referenced on this slide, one in the Fourth Circuit and one in the Second Circuit. So it will be interesting to see how these courts address this issue. Next slide. And just over 2 months ago, perhaps realizing how much discussion was going on regarding McGinnity, the Ninth Circuit clarified its analysis in McGinnity when faced with a case where there was baby wipes where the front label used the term plant-based wipes and natural care. There, the lower court dismissed the claims, relying on McGinnity because the back label dispelled whatever misrepresentation allegedly exists. The Ninth Circuit reversed, stating that the plaintiff must only plausibly allege that the front label was unambiguously deceptive, and that the plaintiff had done so the court could not consider the back label. Notably, the Ninth Circuit clarified what it meant by ambiguous. It stated that a front label is not ambiguous if it could have more than one possible meaning, which is what many of us who argue over whether contract terms are ambiguous interpret ambiguous to mean, but rather a term is ambiguous if a reasonable consumer would necessarily require more information before reasonably concluding that the label is making a particular representation. The court also clarified that the precedent makes clear that consumers of everyday items, such as baby wipes, are not expected to study labels with the same diligence as consumers of specialty products. So it'll be interesting to see what impact there is from this recent clarification. Next slide. Switching gears a bit, the Second Circuit has recently addressed what a plaintiff must do in order to defeat summary judgment on a false labeling claim, and that is offer admissible evidence. In re Kind before the Second Circuit concerned the all-natural label on 39 different Kind products. In the complaint, the plaintiff provided 5 definitions of all-natural and alleged that 11 specified ingredients in the Kind bars were non-natural. In considering summary judgment, the Southern District of New York found inadmissible a consumer perception survey and related expert testimony because the questions were biased, leading, worded based on plaintiff's theory of liability, and led the consumers to pick the answer that supported plaintiff's theory of the case, that all natural meant no artificial or synthetic ingredients. The Southern District of New York also found inadmissible a chemist's report as to whether certain agreements were natural, because this determination as to whether they were natural were based on the way he defined the term, and therefore was not relevant to how the reasonable consumer understood the term. After excluding the 2 expert reports, the Southern District of New York granted summary judgment to Kind finding that plaintiffs had not established how a reasonable consumer would understand the term. The Second Circuit affirmed on the basis that plaintiffs did not present any cohesive definition of what a reasonable consumer would expect from a product labeled all natural, and that without such evidence of a reasonable consumer's understanding, they could not defeat summary judgment. The Second Circuit also found that the trial court did not abuse its discretion in excluding expert testimony because this expert testimony provided no useful information and was not relevant to the task at hand, which was the reasonable consumer's belief. And the court expressly rejected plaintiff's assertion that any criticism of the methodology affects the weight of the evidence, but not the admissibility. Next slide. And while the Second Circuit and N. Ray Kind addressed what is required at the summary judgment stage, the Sixth Circuit just 2 weeks ago addressed what is required at the pleading stage, so specifically that it is not sufficient to merely allege that a label is deceptive, but a plaintiff must explain how and why the label is deceptive, and more importantly, how the plaintiff knows this. In Greer, plaintiff alleged that the label 100% raw Tennessee honey was deceptive because the honey was cooked when processed, therefore not raw, diluted with corn syrup, therefore not 100% honey, and sourced from Vietnam. The Eastern District of Tennessee dismissed for failure to meet Rule 9 standards, and the Sixth Circuit agreed, finding that the plaintiff did not factually allege why the statements were false and how the testing correlated to the allegations. Thus, it appears that plaintiffs must do their homework before filing deceptive labeling claims and set forth how, why, when, and how they know in detail. And the next slide. The last case I want to address is Davidson versus Sprout Foods out of the Ninth Circuit in June, which the Ninth Circuit said was the first case to reach it involving the Sherman Law, which is California's food label law, which mirrors the federal law. However, the federal law does not provide for a private cause of action. In this case, a set of parents claimed that Sprouts pouch packets for infants and toddlers had labels that could mislead parents into thinking the products provide health benefits. The Sherman Law, just like its federal counterpart, prohibited nutrient content claims on food for children under 2. The parents brought a number of causes of action based on the labeling, but one was a California unfair competition law claim, a UCL claim, based on violations of the Sherman Law. And the district court there found that the Sherman Law claim was impliedly preempted, dismissed that claim as well as the other claims. So the question before the Ninth Circuit was whether California's requirements in the Sherman Law could be privately enforced, or whether the federal limitation, which preempted private enforcement of the federal law, preempted private enforcement of the state standard. In a split panel decision, the court found that the private plaintiffs could bring claims for violation of the Sherman Law, which mirrored federal law, specifically stating that there is no reason we can perceive why Congress would permit states to enact particular legislation and then deny enforcement by their citizens. Federal law does not support such a strange result. Now, the Ninth Circuit, in line with the other cases I just discussed, did affirm the dismissal of the fraud-based claims for failing to allege with particularity why the products were actually harmful. With that, I'm going to turn it over to Bethany, who will wrap up this section and then close out this program addressing mass arbitration. Bethany?
Okay. So we want to make sure that we wrap up and discuss mass arbitration and arbitration generally, which is a topic I think on many of your minds, but I wanted to just point out a couple of things and talk about some trends. I wanted to point out this Drake case that comes out of the Southern District of California this week. Julie talked about admissibility of expert studies. This decision is a little bit unfortunate. It grants class certification, in a natural claim dealing with one-a-day multivitamins. And in this case, the court really focused on a couple of issues dealing with predominance, materiality, reliance, and the ability to prove class-wide damages. In this case, the court, relying on the Lytle decision out of the Ninth Circuit, said that you didn't actually have to go through the conjoint analysis, which is an expert analysis that we often see plaintiffs' experts using in order to preview class-wide damages. They just had to come up with a model. And so very different from the admissible evidence standard, this court did not weigh in on a battle of the experts, did not look at actual damages models. Those were not used or applied to the circumstances here, but just merely presentation of a model itself was sufficient for plaintiffs to get over the predominance hurdle. One other interesting thing about this case is that they looked at the documentation in the marketing department and really took issue with the marketing department's discussion and pushing to use the word natural in conjunction with the advertising. And they basically said, well, if it's not material, or if the company didn't believe that consumers would rely on that word, then why include it in the marketing at all? Next slide. So we have some product labeling trends and predictions that we have. I think that despite McGinnity, we are still going to see quite a few challenges on the, particularly given Whiteside, as to whether you can rely, whether something's ambiguous or not, whether you can use the packaging as a whole. And it'll be interesting to see how much Whiteside diffuses some of the really great decisions that have relied on McGinnity. There's still a whole lot of causes of action being filed with natural or environmental type claims. We're seeing lots of cases involving microplastics, PFAS, natural preservative derivatives. We're seeing lots of cases involving pricing practices in the false advertising space. And we will be catching everybody up on these decisions, hopefully in our end of year wrap up in December or January. Next slide. So I want to talk a little bit about some trends and things we're seeing with mass arbitration. So class actions obviously allow a company and plaintiffs to adjudicate a particular claim on a class-wide basis. We are seeing tons of activity this year and at the end of last year in mass arbitration. As those of us who have been practicing in this space for many, many years, arbitration clauses were added to many things like website terms, consumer contracts, as a potential deterrent to mass litigation or class actions, which were found to be very dangerous from a company perspective, sort of unknown and untested in many instances. And arbitration was thought to be a method to deter litigation and to also reduce costs. At the time that those arbitration clauses were being used in the consumer context, there were very few firms out there on the plaintiff side that could manage large dockets and attract and sign up individual participants. We have seen in the SIPA litigation, the invasion of privacy litigation, in BIPA cases, the biometric front, VIPA cases, the Video Protection Privacy Act front, and even more recently in false advertising cases, that tide has really shifted. Social media has made it incredibly easy for plaintiffs to run ads, sometimes using the very technology they're complaining about, to target, to attract, and to identify and engage claimants. In addition, there are companies out there that are assisting plaintiffs' firms with the administration. There are also firms like funding firms that are assisting plaintiffs' firms to bring these kinds of cases. And so the analysis and the settlement discussions have really changed from a what is the damage figure associated, for example, with the dropping of a pixel or the sharing of information or collection of information from some piece of ad tech, or the reliance on a label claim, which in some instances is a very, very, very small damages number, to a discussion on what are you as a company going to have to expend in filing fees and arbitrator fees in order to be able to say word one about the merits of a claim. And so this big shift has really engaged us in questioning the use of these arbitration clauses and alternative solutions. Next slide. In response to the sort of outrage by companies of this mass arbitration process, the two of the main arbitrable bodies, the AAA and JAMS, have enacted in 2024 new mass arbitration terms. And the details of all of these terms are set out in their rules. But one key distinction to keep in mind if you think you want to be using these rules is that AAA and JAMS differ in the threshold numbers for applying these new mass arbitration rules. And JAMS takes the position that unless you specifically reference use of these mass arbitration terms in a binding arbitration contract, even if you reach these thresholds, they will not apply these mass arbitration rules absent agreement. And we don't believe that plaintiffs' counsel will be motivated to agree to these terms because they lose their bargaining power associated with the very high fees, filing fees and arbitration fees dealing with mass arbitration. Next slide. So what do you do if you're facing one of these mass arbitrations? One of the key decisions coming out of 2024 lends some guidance and some tools to be able to help with getting a arbitrable body to defer ruling or defer processing and intake of certain numbers of claims. And that's the Coinbase case. So if you're dealing with certain potential terms that might be competing, for example, a set of a class waiver or a regular contract that doesn't have terms and conditions associated with arbitration and one that does, or two different contracts, one that might refer to AAA, one that might refer to JAMS, or some sort of combination of contracts that could apply to the situation, Coinbase basically stands for the proposition that in those instances, under the FAA, it is a court and not an arbitrator who determines issues of arbitrability. So the arbitrable body should not be ruling and processing those claims and associating payments with those claims until a court decides, is there a contract and what contract here potentially applies? And that's what Coinbase stands for. Next slide. There are two other cases that have come out in the mass arbitration context in 2024 that I think are very helpful. One of these cases is the Samsung Electronics case out of the Seventh Circuit. And I think we reported on this in a prior discussion associated with BIPA, which is Illinois' Biometric Privacy Act. In that case, there was a firm that had brought over 35,000 claims to the AAA, and the AAA, in conjunction with those claims, after some back and forth and some amendment of the claims by plaintiffs' counsel and their claimants, AAA assessed $4 million, over $4 million in initial filing fees. That's just filing fees. That has nothing to do with actual arbitrator fees. And Samsung said, wait a minute, I'm still not sure that these claims are valid, that they're brought by real customers of ours, and they refuse to pay the fees. AAA, under their discretion, shut down the case, closed the case, and basically told plaintiffs, you need to go to a court if you want to proceed. Plaintiffs' counsel, instead of suing in court over the BIPA claims, asked for petitioned to compel arbitration under the FAA. The district court, based on the evidence that was submitted, found that claimants had sufficiently established valid arbitration agreements and ordered Samsung to pay fees and proceed to arbitration. And that was the decision that we talked about in the last session. The Seventh Circuit reversed. Basically, the Seventh Circuit said claimants did not prove that they actually owned phones and were customers of Samsung. And as a result, they reversed the case. They also found that the court exceeded its authority to order payment of the AAA fees. So even if the court had found that a sufficient relationship existed, it was under AAA's authority, as the cases had gone to arbitration per the contract, to shut it down and to refer it back to court. And so that's a really defense-friendly decision. The L'Occitane case is another one of these helpful conditions where you might be facing claimants who you don't believe necessarily have a relationship or a contract with you. And there they found that just visiting a website was not necessarily sufficient to establish a contract evidencing a transaction in commerce, which is the standard under FAA, to bring the dispute and to under the FAA and to compel arbitration. And that case was a SIPA case. So I think the question then turns to, next slide, can I simply include a class waiver? Can I get rid of the arbitration clause and just include a class waiver, which is one of our recommendations right now? And I think the answer is that we're going to see how that shakes out in the various different courts. There are decisions in New York, New Jersey, Pennsylvania, and Georgia that support the use of a straight class waiver without an arbitration clause. And the key issues there are going to be unconscionability, and does the statutory scheme that plaintiffs' counsel are suing under suggest that class waivers should not be enforceable, and the best way to proceed is with a class action. So I think the American Express case versus Italian Colors out of the Supreme Court is going to, that guidance will still be relevant in determining class waivers. And we are going to just see how these issues shake out in court. Personally, as a class action litigator, if the class waiver is found to be unconscionable, we still think that you're going to be better off in a court dealing with a class action and fighting the class action under current jurisprudence than dealing with the expense and unpredictability and lack of appeal circumstances that exist with mass arbitrations. Next slide. We are at the close of our time, so I want to make sure that I provide the second CLE code, which is pumpkin. If you missed the first CLE code, I'm going to give you a gift. That first CLE code was apple. Second one is pumpkin. If you have an opportunity, please join us again and our advertising team on September 26th, looking at the FTC's final rule on consumer reviews and endorsements. And this concludes our program. We hope that you will join us again in January, where we look at developments in the second half of 2024 and things that we expect to see in 2025. And please make sure you do the post-webinar survey so that you can get your CLE credit. If you have any questions, reach out to ClassActionEvents@bakerlaw.com. Thanks again for joining us.